You're about to hear two things that could break this case wide open. First, the video that should exist doesn't. Second, the governor said something he probably shouldn't have. Tyler Robinson turned himself in for the assassination of Charlie Kirk. You'd expect that moment to be on camera. Sheriff's offices have cameras everywhere. Doorbell cameras catch package thieves. Gas stations catch shoplifters. So how does the surrender of the most high-profile suspect in Utah's history go completely unrecorded? Nobody has given a real answer yet, and that alone should bother you. That's Promise 1. We're going to show you exactly what the sheriff's office said when asked for that footage, and why their answer doesn't add up at all. Here's Promise 2. Before a single piece of evidence went public, before anyone knew what was on Robinson's phone, Governor Cox stood in front of cameras and said Utah would seek the death penalty. Not after the trial started, not after charges got filed, before almost anything went public. You need to understand why that timing matters so much. It's not just political theater or an emotional reaction. It could become a real legal weapon for the defense team. 2 threads. One missing tape from the night he surrendered. One governor who spoke too soon, before the evidence even existed. By the end of this video, you'll understand exactly how both of these could unravel the state's entire case against Tyler Robinson. Stick with us until the end. This one gets complicated fast, and it only gets more unsettling from here on out. You'll want to see exactly how these two pieces connect. To understand why this video's disappearance matters so much, you need to see exactly what happened that morning. Evidence. Let's walk through the actual timeline. Robinson surrendered near his parents' home in Washington County, Utah. He confessed to them first, then he turned himself in at the sheriff's office. Officials say he arrived around 6 a.m. He went into a secure area marked Authorized Personnel Only. The sheriff's office notified the FBI in Salt Lake City. They kept him in the back offices until federal agents arrived. Investigators described him as quiet, somber, almost resigned to what was coming. Now here's where it gets strange. When reporters filed public records requests for surveillance footage of that surrender, the sheriff's office gave this exact response. Our office did not have any applicable records responsive to this request, as the surveillance footage is no longer available after the 30-day retention period. Read that again slowly. One of the most significant law enforcement moments in Utah's history, and they say the tape simply expired. This is Promise 1, delivered. Defense attorney Clayton Sims explained why this detail should raise your eyebrows immediately. It is odd. If a secure facility has cameras throughout the facility, there would be multiple cameras at the entrance and the interior of the building. Think about that for a second. Sims has handled death penalty cases before. In one, police recorded a suspect's entire drive across the state, just to preserve every word and reaction. That's standard procedure for a case this size. So why is Robinson's surrender the exception to that rule? Sims points out something most people miss. A missing tape isn't just an inconvenience here. In a death penalty case, a peaceful surrender actually helps the defendant. So losing proof of that surrender doesn't help the defense at all. It raises a much bigger question about who actually benefits from the silence here. And once you frame it that way, the missing footage stops looking like a clerical mistake. It starts looking like a decision someone else may have made, whether they meant to or not. And that changes how you should read everything that comes next. But the missing video isn't the only thing raising red flags in this case. Key question. Now let's talk about Governor Cox. This is Promise 2. Very early on, before evidence went public and before charges were finalized, the governor stood at a podium and said Utah would pursue the death penalty. Not the prosecutor, not the attorney general, the governor himself. Here's why that single statement could matter more than you think. Clayton Sims walked us through 5 specific problems with that timing. 1. The specific legal factors required to justify a death penalty case weren't publicly confirmed yet when Cox spoke. 2. Comments like this from a sitting governor can taint a jury pool before a single juror even gets summoned. 3. The governor appointed the judge now presiding over this exact case. That connection is impossible to ignore. 4. This wasn't a private remark between staff. It came from the state's top executive, on camera, for the entire country to hear. 5. And here's the one that changes everything. Sims believes the governor himself could actually get subpoenaed. This governor could be subpoenaed. What information did he have that he was pushing for that? Sit with that for a second. The person who appointed the judge might get called to testify about political pressure on his own case. That's not a minor detail. That's a real complication for the entire prosecution. Sims doesn't think Cox did this strategically. He thinks it came from somewhere more human. I think that the governor's human. The governor reacted to the situation and was passionate about his position. Human, sure, but human mistakes still carry legal weight in a courtroom. Defense attorneys don't care about intent. They care about leverage, and leverage is exactly what this statement may have handed them. So ask yourself this. If the governor's own words end up helping Tyler Robinson's defense, what does that say about how this entire case was handled from day one? It's a question the prosecution may not want anyone asking out loud, and it's not going away anytime soon. Do you think the governor's comments could actually be used against the prosecution? Tell us below. And the person now responsible for sorting through all of it? Someone barely 6 months into the job. Suspect truth. Meet Judge Tony Graff. 6 months on the bench, and that's it. Somehow he landed the biggest case in Utah's history. It wasn't rigged, and it wasn't political. Utah assigns judges through a random computer algorithm, specifically to prevent favoritism. Graff simply happened to draw the case of a lifetime. Here's the detail that should unsettle you. Governor Cox appointed Graff to the bench. The same governor now facing questions about his death penalty comments appointed the judge deciding whether those comments actually matter. So, how is Graff handling it so far? Better than you might expect. He's already issued a gag order to stop both sides from trying this case in the media. He ruled that Robinson can wear civilian clothes in court instead of a jumpsuit, to protect the presumption of innocence. He's also limiting how cameras can frame Robinson during appearances, keeping restraints out of view. Clayton Sims, who's tried cases against Graff before, says he's handling the pressure well so far. I think that he is handling the case actually at this point. Great. He's limiting both sides through the gag order. But here's the catch. A judge can make the legally correct call and still make the deeply unpopular one. And in Utah, judges aren't appointed for life. They face retention elections, which means the public can actually vote them out. One controversial ruling in a case this size, and Graff's entire career could become the next thing on trial. Every decision he makes from here gets measured against a national audience that's already watching closely, whether he likes it or not. Should a judge with only 6 months of experience be handling a case this size? Let us know. Which brings us to the one decision still hanging over this entire case. Unresolved close. There's still one ruling nobody has made. Cameras in the courtroom. Charlie Kirk's widow has publicly pushed for it. Her reasoning is simple, and it's hard to argue with. Charlie Kirk's death happened on camera, in front of the entire world. Shouldn't his trial be visible too? Judge Graff hasn't ruled yet, and every choice he makes from here gets measured against a case that's already under a microscope. A missing surveillance tape nobody can explain. A governor who spoke before the evidence even existed. A rookie judge holding all of it together. None of this is resolved. Not the video, not the subpoena question, not the cameras. That's the truth about high-profile cases like this one. They rarely move in straight lines. They move in fragments, one ruling at a time, one records request at a time. We'll be watching closely for that camera decision. When it drops, we'll break it down here, piece by piece, just like we did today. New details tend to surface fast in a case this big, so you'll want to be here when they do. Do you think cameras should be allowed in this courtroom? Comment yes or no below. Subscribe now so you don't miss the next update in this case.